Hello, everybody. Thank you for joining this live. At the very beginning of this session, I'm going to wait for a couple of seconds for the rest of the audience to join. And as I've told you before, I'm really honored today that we have as guest our speaker today, Miss Erica Wee from Singapore Management University. Welcome everybody to this live with the live conversation I'm having today with Erica Wee from Singapore Management University. I'd like to first of all thank the Scientific Association of the Law Students of the University of Tehran for supporting this live to be held just today. Also, in parallel, I'd like to thank dear Professor Nicholas Louis from Singapore Management University that I was connected with him regarding this live to happen. So first of all, I have to mention that I had this honor of meeting with dear Professor Nicholas Louis in Washington, D.C. in 2023, in which I had the honor of watching the semi-final of the international rounds of the Jessup competition. So that day, when I witnessed for maybe third or fourth time in my moot experiences, the way Singapore Management University students mooted, I was really inspired and motivated by the high quality of the performance and oral presentation. Maybe some of you are not aware of the Jessup competition, but to begin with, I have to come up with a very brief introduction of the Jessup competition. This is the oldest international law moot court competition, which for the very first time was held in 1960, 65 years ago, in which two universities from Harvard University participated. Over the years, after 65 years, we witnessed that in 2025 Philip C. Jessup version, 805 teams, the law faculties, different universities representing 104 countries participated in the Jessup competition. It means that it's very hard for the students to go to the international rounds, let alone just being awarded the champion of the international rounds of this year, which was the all-time high record in the Jessup competition with this amount of participants. I'd like to introduce our guest speaker today, Erica Wee, which I'm really honored to talk to today. Erica Wee is a graduating senior at Singapore Management University, Yong Pung House School of Law. She was a key team member of the world's champion of the Jessup 2025 in the Jessup competition, which the achievement that was already and recently achieved by Singapore Management University. She was also awarded the best oralist in the final round and the third best oralist in the preliminary rounds. Over the course of her moot journey, Erica has also taken part in several international commercial arbitration moot competitions, winning prizes and honourable mentions as the best oralist in the 2024 Deakin Moot competition and the 2024 Willem C Vis Moot, and also 2024 PCA Vis Pre-Moot competition. With this background, and at this point, if you have any introductory remarks, dear Erica, you'd like the audience, the floor is yours.
No, actually, I think that was super comprehensive. Thank you so much again for inviting me, and thank you to the University of Tehran. I think really maybe just to caveat everything that I'm going to say from the outset. Everything that I'm going to say is from my perspective as a student, and not just a student, but only an LB student, that hopefully by the end of this month would be a graduate of the university, but maybe we'll see. But point being is that everything that I'm going to share is from my own personal experience, things that I personally found helpful, things that I think my teammates found helpful. But these are things that may not necessarily apply to every single person. Mooting and or advocacy is such an individual journey, and it's a very individual experience. And I think if you were to watch decades or all the different mooters that have come even out of SMU, the style is always going to differ because every speaker has a different thing that they bring to the table. And there is not one perfect style or one perfect approach. And the importance is to just present in a manner that you think best speaks to your strengths and that best represents your learning and what you've learned out of your coaches and from your friends. But yeah, I'm very excited to have this conversation with you. Thank you.
Thank you very much. The honor's mine and ours because I think I have not yet seen any such live recently that someone can speak on a live basis with the best oralists of the world's mostly recognized international moot court competition. But today we have this opportunity and honor to learn from you. And you said that you're the last year LLB student, but you know this does not how can I say that? It does not deduct anything from the value that you have gained through the Jessup competition. So to begin with, dear Erica, would you please walk us through your approach to preparation? Specifically, what steps do you take before, during, and after the rounds to ensure you perform at your best? I think this question may be a common question for all oralists or the students that are willing to participate in the Jessup or other moots.
Right. I think it's great to think about it in terms of what you can do before, during, and after, mainly because I think what you do before helps to frame, for instance, how exactly you're going to be presenting your arguments during the round and how you organize your arguments during the round. And then after, it's always going to be about your after action review, reviewing feedback from your coaches, reviewing feedback from your peers. So maybe just to take these points kind of in turn. So, on preparing before the round, I think the key thing that really makes a difference is how you prepare your bundles, how you prepare what you bring up for the competition. And this is something that I think actually is something that kind of differs from team to team. There are actually teams that truly pride themselves on bringing nothing up to the podium. I think we saw this in the 2024 final, the championship team. I think that was the University of Philippines. Their signature move is they come up with absolutely nothing because they've prepared themselves completely ad nauseum. They have everything down to a T. But for us, we're going to go up with bundles, and I think that's the majority of teams, right? And maybe
Yeah.
just speaking from a respondent perspective, I think one of the key things that I learned when I was in my second or my third year is actually what really helps in being a great respondent is actually having a very modular format of your bundle. And I'm focusing on this particularly because I feel like not many people talk about it. But what I mean by this is essentially what my team and I would do is we organize our notes based on in a way that can be customized to the round. So what you don't want to have is you have a full length script that you can't kind of mix and match and move the different pages around in order
Yeah.
to customize it or personalize it to whatever the applicant is arguing. So what this means is that we would actually have, for instance, there are two issues. So issue one would be one page, issue two would be a second page. And so if you have a judge that let's say says, let's start with issue two, you can immediately move issue two from that back page to the front page. And it's this sort of super small little technical thing that you wouldn't think about when you're preparing, but during the round when it happens, you wish you would have done it. So that was one thing that we really learned about preparing our bundles. And our coaches were actually really good in terms of encouraging us to actually even though we don't want to go up with nothing, we definitely don't want to go up with anything that's overwhelming. What you don't want is a situation where you go up with such a huge pile of notes that you just can't seem to navigate through when you're stressed or when you're looking for something. So having something that is easy to read, that's organized, that's concise, but still comprehensive is super important. The other thing that I think maybe certain teams would find helpful when they think about preparing their bundles is to think ahead about what kind of questions you think you tend to get asked when you raise a particular point, and prepare what you think are the answers that you would like to raise and have them at that part of your outline. Essentially, what you're trying to avoid is a situation where you make a point, and in making a point, you get asked this very common, very frequently asked question, and suddenly you don't have the answer to it, even though it comes up all the time, right? You need to flip all the way to the back of your notes to find that answer. You might as well put it in the front. Another thing, and the final thing I would say when it comes to preparing your bundles before the round, is actually supporting it with your authorities. So doing things like putting your authorities into the same file, rather than having it something that you know it's there, you know that the court broadly said this, but you don't know precisely what the court said. I think for a moot like the Jessup, you are very much tied to the authorities and the language of those. So it's really different. And you can totally have judges at the international rounds that would say, hey, actually, can you read out that line to me? And you want to be able to have that line. So the one thing that our team did was we committed to printing the full cases, or at least extracts of those cases. I know that's super extreme for some teams, but it can be very helpful. And actually, in preparation for today, I was flipping through the file that I actually brought up for the final round. And I did actually put in the full case extracts in between my outlines so that I could refer to them on the off chance that one of the judges had asked me precisely what the court had said. So I think that's what you can do before the round. And this kind of preparation, I think, realistically speaking, 9 out of 10 times, it will not actually be helpful, because it's very rare for a judge to ask you those questions. But what it does give you is it gives you confidence in going into the round, because you know that you have the authorities there, you know that you have the answers there, and you don't feel afraid. And I think how that carries into your performance is really, really important, because confidence, I think, would be the key factor that I think differentiates a team that the judges feel, okay, I feel like you know what you're talking about, versus a sense of nervousness that could betray you and make it easier for a judge that wants to be difficult to kind of knock you off your feet. On things that we can do during the round, I think you actually noted this in your original.
Can I ask you another
Yes.
complimentary question regarding
Yeah.
the steps that your team, for example, you and your teammates, would take before the preparation for the rounds? You mentioned the customization for the respondent role, for example. I need to know more about that. Do you mean that, for example, that before the start of every round in which you have to play the role of the respondent, you have a different strategy for every round, and how you strategize for that, how you build up your strategy and arguments for that? Do you, for example, in your way to the international rounds and also to the final, did you have, for example, two matches which you exactly did the same as the respondent?
To go with the last question, I don't think as a respondent we ever had 2 rounds that were the same. And I would say that if you're a respondent and you do have 2 rounds that are exactly the same and you're running the exact same thing, either you are very lucky or you're not fully appreciating the role of the respondent. I think we don't actually have a approach where we strategize before each round. And this was actually what I was going to cover when I talk about what we do during the round, which is what you do as the respondent is you effectively, yes, you are responding to what the applicant has argued, but more specifically, you are responding to what the judges have shown interest in or challenged in the applicant's arguments.
Yeah.
And so actually, what we do as a respondent is we have the same outline for every single round that we bring in, but how that outline is delivered will of course differ, And how it differs would depend on how the applicant has made their submissions or what kind of questions the judges have asked. And actually, on what you had said earlier in your post about why people tend to be a little bit more afraid of the respondent role, I think that's always because there's a presumption that as the respondent, you don't have that opportunity to just go up with a set script the way the applicant does, right? And because of that, there's always this presumption that the applicant role is easier to execute. And I don't think that's untrue. It is easier to execute the role as the respondent, but I would say that's actually harder to execute it well, because the analogy that we've always used is that essentially when you're the applicant, you are kind of, it's a basketball analogy, I'm sorry, you're shooting in the dark, essentially. You don't know what the judge's concerns are, and they reveal themselves as the questions come. But when you are the respondent, the advantage, even though you have to be flexible, is that you've already seen what the judge's questions, what the judge's concerns are. And so you can really sidestep the parts of the argument that you think maybe are not as relevant, or maybe are not, not necessarily less relevant, because all the issues are of course relevant, but perhaps less contentious to the judges. At the end of the day, when you go to a moot like the Jessup, there are so many issues that you can potentially cover and so many different ways to look at an issue. I think if we just take this Jessup round, for instance, on the third issue, you could view it as an issue of treaty interpretation. You could view it as an issue of the development of customary international law. Or on the second issue, maybe on the issue of immunities, for instance, you could view it as, can you imply a waiver of immunity? Or you can also view it as, is there a customary exception for the immunity? So different ways of viewing the issue. And different judges would care more about exploring one issue than the other. And if you can get an idea of what they actually care more about and invest more of your limited time on those issues, then it actually helps your case. It doesn't actually make it more challenging for you necessarily, especially if certainly by the time you get to the international rounds, you are familiar enough with your arguments, familiar enough with your authorities, hopefully, to make that kind of customization on the fly. And I guess the reason why we talked about making it modular earlier and how we prepare for this kind of customization, the idea is, or maybe one of the things that we also do is we would actually leave space in our outlines and our scripts to actually integrate the judge's questions or integrate these other concerns, or basically make a mark to ourselves to say that, oh, look, they've kind of focused more on this. Let's put more of our time on this issue. And so I would say that the one key thing to do actually during the round would then be to listen very attentively to what not only the other side is arguing, but the questions that come. And actually my second point on this would be to, in so doing, actually really make full use of your off-counsel. So every team at the Jessup gets to go up with technically 3 members, right? You go up with yourself, your co-agent, and then in between, or some people would decide, there is your off-counsel. And for us, our off-counsel was Miss Vis C, and she was really great in terms of actually just keeping track of all the different questions that were raised by the judges and what were some of the key points that the applicant made in response to those questions. And then she would kind of highlight for us what were some of the key questions that we could potentially integrate into our submissions. Of course, as speaker, you want to be doing that for yourself too. Certainly, like that responsibility is primarily yours first. But having an off-counsel that can kind of act as a second check to let you know, hey, this question came up, you may want to use that, is also very useful. And the final check is, of course, your co-agent. I think when you work very closely with your co-agent, and they note that you could potentially raise a particular point, and they can indicate it to you during the round, that is also very helpful. Because, I mean, the applicant is speaking for a total of almost 40 plus minutes. So that's 40 plus minutes that you can sit with your co-agent and kind of get a good sensing of what are the points you want to respond to, and make the most out of your time. The final thing I would say is on after the round, and this was something that my team and I kind of developed slowly through our practice rounds. you always have reviews and you always have feedback by your coaches. But one thing that we really found helpful for ourselves is to actually give ourselves comments and feedback during our practice rounds. So we would just have this very small system of just noting down for each other. For instance, when I listen to my friend speaking or my co-agent speaking, I'll note down, oh, this is what you did well. This is what maybe you could have improved upon. This answer was wrong or something like that. And I think this comes from working very closely together, but it also comes from being very dedicated, very committed to getting better and improving together. Part of this is also just knowing that your friends always mean well, your teammates always mean well, and helping each other along the way. But it's always great to get a perspective from your peers as opposed to necessarily always getting that purely from your coaches. Because while your coaches can view it from that third party perspective, your partner can also see it more from your perspective. Maybe they know, okay, I know why you were running this weird argument, even though we said we were going to run it previously, because you were trying to test this or you're trying to test that. And that kind of teamwork with your co-agent can be really, really helpful and can give you a better kind of sense about how you want to approach maybe your next round.
Can
I
I
would
ask
say
you
that's,
just
yes.
question regarding the role of the co-agent and also the way you're using what your co-agents, for example, writes for you when the applicant is, for example, making his or her pleading. So this is a very, very hard task for you, for example, to can make yourself concentrate and focus on what your co-agent says. And at the same time, when it's your turn, you decide to, for example, repeat those issues and when and how. It is very important and a very rough and hard task. I saw your presentation, your pleading, 3 times in the final, and I noticed that you only looked at your paper not more than 2 seconds. It was something that I witnessed, and even it was not something. When you looked at your paper, for example, your script, it was not for the purpose of seeing something. Maybe for changing the position of your head only and not for a very specific purpose. But how could you manage to receive that point from your co-agent and to know where exactly you have to refer to that point during your presentation? How a person can achieve this high level of performance and preparation?
I would say maybe this question would actually be slightly more relevant for my co-agent because she was the second speaker for the respondent. So she would actually have had to listen to me before prepping for her own round. Whereas for me, I didn't really have to listen to her before going up for my pleading. But I think this is because we've kind of all rotated our roles. So I've been in her position before. I think it really comes down to 2 key things, I think. For now, it's 2. It might be 3 after this. But the first is really understanding the core of your arguments. Because at the end of the day, if you understand your core of your arguments, it's kind of, and I know it's like, it sounds so weird to say it now looking back, because I never would have thought this when I was in my 2nd or my 3rd year. But it is just having a conversation with somebody or about something that actually you know really well, and you potentially would know specifically on the issues and specifically on the facts, perhaps even better than the person you're speaking to. And so, if you really understand the core of what you're arguing, the reference to your notes is really just a reminder, just a guide, just a pointer to be like, this is where you're going to go next.
Exactly.
The second thing I think that really helped me during the final round, especially, was I really made a very concerted effort to speak much more slowly than I normally do. And so
Yeah.
it kind of allows you to think before you say something. And therefore, it's a lot easier, I think, to kind of make sure that I have the point already developed in my head before I let it out to the judges. But I think the first point is the most important, which is really understanding your material. And I think that comes with practice, but it also, I think, comes with understanding truly what's the core of your case. Because yes, there are all these other ancillary issues, or the Jessup is that kind of moot where you have so many issues kind of swimming around amongst each other. But really, when you want to dive into what the core of the argument is, you only really need to remember a few key things. You just need to remember, okay, I'm the respondent and I want this. And after a while, you would know that there are many different pathways in which you can take to achieve that particular outcome. And by the time you get to the international rounds, you will know the strengths and the weaknesses of each path, the authorities that you will need to support each path. And it's just a matter of deploying them or deploying these layers as and when the judges lead you in that direction. I think those are kind of the key points, but maybe one thing that I think differentiates maybe Singaporean mooters, or the way that Singaporean mooters would have to prepare as compared to maybe mooters from other jurisdictions, specifically on the Jessup, which is, yes, people think that we do way more practice rounds than other teams or other universities, but if you actually look at it, I would say that the reason why we have to do that is also because, unlike so many other teams, we don't have the privilege of, not privilege, okay, we don't have to do a national round, or we don't do a national round. So because Singapore is able to send 2 teams every single year, and we only have 2 law schools that compete.
So you said that you don't have a national round?
We don't have a national round.
Oh my God, didn't know
Yes. So
So only NSU and SMU are
That's
only representatives from your
only
country.
only SMU and NUS do.
And SMU and the US, yeah.
Yeah, and because of that, we don't have a national round. So other people would like look at us and be, oh, you guys do so many practice rounds. When actually, I would argue that if you count it together with the national rounds that other universities end up doing, I would say that we practice in a similar to a similar sort of extent and a similar sort of capacity. And I think the key difference here would be that we also have to do more practice rounds, mainly because you're always going against your own team or going against each other. You never get that chance to be a true respondent until you go to the international rounds, as opposed to teams that have kind of gone through and prevailed through their national rounds. You get to see that diversity of arguments raised by all these different teams that are prepared separately and independently from you, and that gives you way more of an opportunity to practice being a real respondent. So I actually think that this is something that, while it's great, I'm not complaining that we didn't have to do a national round, because that would have been difficult, but it also comes with that slight disadvantage, and something that I think other teams need to keep in consideration when they think about, oh, is it just a matter of volume of practice rounds? I would say not necessarily. And for us, it is specifically because of this difference for our jurisdiction.
Thank you very much. Also, let me ask you one follow-up question, which is related to the importance of teamwork in moot competitions. I know that you referred to some of the points when you were referring to the importance of the role of co-agent, or I will call it co-counsel, because I do believe that those people that are appearing before the International Court of Justice, maybe they are playing the role of the counsel and not necessarily representing the government. So could you elaborate on how you and your teammates collaborate throughout the competition? How do you divide responsibilities and support each other as a team? And in case of, for example, challenge, what are you, for example, doing in this case?
Maybe to give a bit of context. So for my team, we are a team of 5 participants, and we have 1 student assistant coach. So that basically makes it 6 of us, right? And even though in the knockout rounds, technically there were only 3 of us, myself, my co-agent, and our off-counsel, really, there are still 6 of us. And actually, we were really well supported by the non-speakers who were actually, they were speakers at the preliminary rounds, and so they had just as much. In fact, I would say that my partner had even more understanding of the arguments and PIL, and really they were like our individual coaches who would sit with us before the rounds. They would run us through the questions that they think we were likely to get asked, query us specifically on key points and key arguments. So my partner was actually Miss Rayleigh Toh, and basically before the round, she would remind me. She'd be like, "Previously, you gave this answer to this question. That was wrong. What's the correct answer?" And then I would have to practice that. Or she would remind me of certain points that need to get raised. And actually, what was really, really helpful was my coaches at certain points, if they felt like we would be overwhelmed by too much information, what they would do is they would speak to our partners and allow our partners to deliver that information to us in a more kind of streamlined or more concentrated, focused kind of fashion. And I actually found that to be really, really useful. So it's not just about working with your co-agent or your co-counsel at the table, but it was really even before the rounds. They helped us in terms of maybe, let's say we received a question and we were like, hey, actually, I'm not too sure about the authority. Can you help us check that up? And they would do that for us just immediately. And they would support us with any extra research that we needed on the fly. But also, it's just, I think at the end of the day, beyond just that actual real substantive help, it's also just a measure of, or it's just a way of making you feel like you are well supported. So that again, you go up for every single round feeling like I have a team that supports me and I have a team that is able to deliver for me when I need it. And I think that's the most important, feeling like you are well supported and feeling like you can be confident in the preparation that your teammate has done for you. So you can really kind of trust fully in the information you've been provided, and in the training that not only your coaches but your teammates give you. And I think that comes with a lot of trust, but also a lot of mutual respect that you build up for each other after working for months
Exactly.
together.
Exactly. Thank you very much. Okay, please proceed. Yeah.
Yeah, I think maybe one other thing that I think is really useful when it comes to working in a bigger team, of course, I think you alluded to it about division of labor. I think it's really good to, I think some teams, they like to specialize. So some teams will do that thing where one speaker is only ever respondent first speaker, or one speaker is only ever applicant first speaker, and you have that kind of specialization and expertise in that role. And I think that that's very valuable, and I think that's very important on some level. But also, I think that we found that occasionally taking the opportunity to make submissions in a different role was actually very, very helpful in terms of giving us a better understanding of the kind of arguments that the co-agent will be running, but also the kind of arguments that you may have to deal with eventually when you do the rebuttal or the surrebuttal. Because at the end of the day, only one person does the rebuttal and the surrebuttal, and 90% of the time, I would say any good team would want to deliver a rebuttal that covers issues from both speakers, so that it's not just narrow to one specific set of issues. And so you would want to have a little bit of diversity in your practice rounds and sort of have an opportunity to get familiar with the other issues and the other submissions of your co-agent, especially because I think maybe this year's problem was a bit different, but I would presume that in many years there can be certain questions that kind of cut across the issues, and having a good degree of consistency in the approach that you bring forth as first speaker and second speaker can be very, very helpful, especially because you go one after the other.
So if I remember correctly, you were the speaker, the oralist for the first two issues. Am I right?
Yes.
For the final.
Yeah.
So you said that for for a good performance in rebuttal or surrebuttal, the oralist has to know about the other issues, because the strategy for doing so, sharing some points of difference in the rebuttal and surrebuttal, the responsibility of which lies in the other co-agent or co-counsel, is very important. But can I ask you these questions much more precisely, that how much did you know exactly about the third and the fourth issues? And how much time did you dedicate to know about those issues? And were you ready to answer all types of questions that if it was asked from the second oralist? I mean, did you have the same level of performance and preparation like the second oralist of your team?
I would say definitely not to the same full extent, but I would say that we were each comfortable enough in each other's submissions. I would actually be confident enough to say like a 80% confidence in each other's issues, because we would rotate every couple of practice rounds in order to get a good sense of what are the arguments and what are the questions. And I think, honestly, after many practice rounds, even if you're not necessarily arguing that position, you've heard it enough times to broadly have a good idea of what are the arguments to be made and what are the authorities to be cited and the broad propositions that are being proffered by either side on the other issues. And actually, okay, but on this particular point, I think actually I can take that most recent question about grave mistakes or errors during the competition. I think the one thing that I really struggled with at one point, I think this was the Octo Final or something. Uh, Sometimes this happens, and actually not just sometimes, very often it does happen that judges will try and ask each speaker questions that are actually relevant to the other speaker, mainly to just see how well your preparation has been. Is it in a manner that makes you too siloed or too focused on only your issues and you're not able to engage with anything in your co-agent's issues? And at one point, I think I was asked a question that I kind of struggled with at the start, and it was actually about my co-agent's submissions. And I think that was one of the moments where was one of those questions that had me a little bit shaken. So I would say that having a good understanding of your co-agent submissions can be very, very useful. And it doesn't really have to be a situation where you have to always be practicing your co-agent submissions. It can really be a situation where every couple of weeks or so, you sit down with your co-agent and you run each other through your arguments in a casual manner. You just say, this is what I argue, this is why I argue it, these are the authorities I cite, this is what the authorities say, and basically just refresh each other on the arguments that you're each going to make. I think the point is just to never get caught out in that same manner, especially because I think it's becoming a thing for judges to ask those sort of questions.
Can I also ask you a question that relates to the time that is prior to the selection of team members? I need to ask a question, if I'm allowed to, that what strategy does your university follow, for example, to select the individuals from Singapore Management University for its team in the Jessup, and how many applicants, for example, are there that are ready, for example, to be a member of a team? Is it a very different process than, for example, other universities here? For example, here we do something like a maybe written of a very quick or short memorial that they have to write, so we can assess their writing skills, and at the same time or after that we ask them some oral questions to evaluate their oral advocacy skills, their knowledge of law, level of English, I don't know, the format of the quality of presentation and performance, something like that. Can we know something about these stuff?
Actually, because I was only a participant, I actually had no idea, and I still have no idea as to how they selected us into the team. It was it can be a pretty opaque process, because ultimately I think coaches always have their own idea of what they think makes a good team, and I think every year it depends on the applicants, on the maybe how they want to put all the different applicants together. So I'm not too sure precisely how we are selected or why we are selected. But maybe from my perspective, I was actually, when I applied for the Jessup, I think my biggest concern actually was the fact that, I think you alluded to it earlier, but I didn't actually come from a public international law background. So the moots that I'd done
Yes.
previously were very focused on international commercial arbitration. And it's actually my understanding that in other jurisdictions or in other universities, how you train your mooters for PIL moot is very different or almost separate from training mooters that do the international commercial arbitration moots. I think that's the case for some Indian universities. So they're completely different tracks. And I think that was actually the thing that I took the most time to adjust to. So my team, actually, we were super lucky. We were comprised, half of my team were part of the team that had literally, at the time at which we were starting to prepare for the Jessup, had literally just won the 2024 Manfred Lux Space Moot. And if anybody knows anything about that moot, that's like one of the oldest public international law moots. It's super similar in certain ways to Jessup, insofar as it's also public international law. It's also before the ICJ, and the caliber of judges that they actually bring up for the Lux Moot are really, really high. I think my teammates got to plead before also 3 judges of the ICJ doing their finals. And so they had that PIL background that I actually think was really, really, really helpful. So my partner that I was talking about earlier, Miss Rayleigh Toh, so she was from the team, and she has like an encyclopedic knowledge of PIL, and that was very, very, very helpful for me, because I was coming from this arbitration background where I wouldn't say arbitration is necessarily easier, but it's an entirely different ballgame, right? Because you're much more concerned with what is commercially sensible, what makes sense to a commercial party. And at the end of the day, the arguments always go down to things like party autonomy, certainty of commercial parties, what commercial parties would reasonably have wanted in those sort of situations, which is very distinct from how you would do public international law moot, where you're very focused on authorities, and the concerns of the first principles that you have to apply are so different in state sovereignty and sovereign equality arguments like that. But I think actually, in a certain sense, coming from a different background, when I look at it now, looking back, was actually also helpful for me, mainly because I think the stylistic things that you pick up from doing an international commercial arbitration moot are a little bit different, insofar as the focus is a lot more on being conversational, engaging with the bench, because arbitration is a little bit more, I wouldn't say casual, but it's more informal, right? And it's a little bit different from the kind of stand-up formality that you have with moots like the Jessup. And I actually think that helped me build a little bit more confidence in being a lot more conversational and a lot less scripted. So this actually would go back to what you had raised earlier about not referring so religiously or so strictly to your script, because you try and internalize the arguments and put them forth as a conversation that you're having with the bench, as opposed to some internalized monologue that you're just reciting over and over again. I don't think it's necessarily true that just because you do arbitration, you develop this particular skill, or just because you do a PIL moot, you don't develop that skill. I mean, my teammates all had it anyway, even though they didn't have that arbitration background. But I think, if anything, I thought that the diversity of our backgrounds was actually very helpful in building up our team. Yeah.
Thank you. Let's move on to the next question, which came to my mind, and that is, was there any very difficult time for you when you were asked a question from a judge or a bench that you don't know the answer of, or you at least did not predict during your practice round? What was your reaction, if any, if there was such an opportunity or time for you, which may be improbable? But what was your reaction in case of such a circumstance?
I think the one point at which I was actually quite caught off guard was, I think it was the quarterfinal. So during the quarterfinal, I had a judge that asked me, do you know anything about the Legrand case, the 2001 ICJ Legrand case? And he, I think, was, he worked for the US State Department or something like that. So he was very, very familiar with that case. And even though I know that the Legrand case exists, I know the year in which the Legrand case was decided, I know nothing about what actually happened in that case, what that case was about, or the broad proposition that that case even stood for. I have no idea how it relates to my submissions. And so in that moment, he said, do you know the Legrand case? And I had to just admit that I don't. I think in that moment, you get a choice. You either pretend that you do and hope they don't ask you more about it, or you admit to the fact that you don't.
Yeah.
And I think for me, the way I ultimately went about it was I admitted that I don't know the case, but if Your Excellency would be so kind as to brief me on those facts, I'm happy to engage on that particular point. And I was lucky enough that the judge was happy to just give me a brief overview of what about the case he thought was relevant. And then in that moment, I was able to say, okay, how can I apply that case to whatever I have at the moment? I think the way to deal with those sort of questions, those left field questions, probably looking back, it wasn't very left field and I should have been prepared for it anyway. But I think the way to deal with it is to just, number one, trust your own training. So the first level is that surely by the time I get to the international rounds, I should be able to answer most questions, even if they're unfamiliar to me. Because at the end of the day, if I know the broad contours of the arguments that I have to make, and I know the broad landscape of authorities that exist, I can surely string something together, even if it's for the first time that I'm hearing it. The other thing is, I think, having confidence that even if I can't answer them at this particular point, I have so much more that I can offer them. Even if it gets to the point that I have to say, I don't know, you can still go to it. In any case, I have this other authority that supports a proposition. And I think most judges, even at the international rounds, are sympathetic to the fact that they're asking you a difficult question. A judge knows when they're asking you a difficult question and they're trying to challenge you. And even if it's wonderful and amazing if you can respond to the question, I don't think a judge would necessarily hold it too much against you when you can't answer that question. And so I think just being honest in that moment and trying to engage the judge where they are, meet them where they are, and see if they're able to assist you, to assist them, I think is the most important. And so just having that posture of being very earnest and being very sincere to support them or to assist them in trying to understand the case will be my approach generally, even if the question is something I was not prepared to deal with.
Okay, let's move on to some of the questions asked by the audience, if you're ready.
Yes.
One of the students asked the question, how many hours did you practice a day? Because you Hello?
Hi.
Do you hear me now?
I think you were asking the question about how many hours I prepared.
Yes, I did.
Okay.
Yeah.
Okay, all right. We had practice rounds, we had weekly practice rounds. We didn't necessarily practice every single day, but I would say that it doesn't necessarily have to be a matter of quantity and volume of practice. I think it's about the quality of each practice round and making the most out of that practice round. And so I think that kind of goes back to what we were talking about earlier, making sure that after the round, you do a full proper review with your coaches, with the judges, and the feedback that they give, but also with your peers, talking to your co-agent, talking to the other speakers and saying, hey, did you understand me when I raised this point? Did I do that well, or did I do that better last time? Is this version better? What about this version is better? And getting a proper kind of breakdown as to how that practice round was useful. Because I would say the last thing a team would want to do is to just hit volume of practice rounds alone. Just do round after round after round after round, but change nothing about their submissions. Because at that point, then I would say that doesn't really achieve much. If anything, it burns out the team. So I think the difference is you can have less practice rounds, but focus on refining your arguments within every round and making sure that each round is fully maximized and its use is fully maximized. But I also understand that this is something that we also have the privilege of saying, because for us, we do these moots with English primarily being our first language. And that's very different from teams that are maybe doing it as a second language, or for some people, even a third language, which is always just so impressive, right? And so maybe in those situations, I would say that maybe volume could be helpful. But I think at the end of the day, if the focus is really on refining your arguments, refining how you respond to questions, then focus on having good practice rounds, full practice rounds that you maximize, rather than simply just doing multiple rounds back to back to back where nothing changes in between.
Thank you very much. I think all other questions asked by the audience in the comment section were already covered by you. Do you have any last point you'd like to share with the audience today?
Uh,
At the end, maybe.
Um, okay, maybe just like a closing point is, I think going back to what I said at the start, at the outset, I think at the end of the day, mooting is a very individual um, experience and a very individual approach. Advocacy is individual. I mean, the strength of every advocate is in what they specifically bring to the table, and personality is important. Personal style is important. I don't think that we would want a situation where every single mooter sounds the same. Every single mooter takes the same approach and delivers their arguments in the exact same fashion. I don't think that that would make for very lively or very entertaining or even very productive moot competitions, right? So I think focusing on how you yourself bring different strengths. I mean, by the time you get to competitions like the Jessup, there has to be a certain amount of confidence and faith in the fact that you were selected because you bring something great to the table. And what that means is you shouldn't be expecting yourself to change to fit a particular mode or a particular model. I think sometimes we tend to fall into those traps of watching a particular speaker and saying, I want to be just like that speaker and emulate that speaker. I think for me, I went through a phase of watching one of the Australian speakers from I think the 2015 final or something like that, like a couple of times. But at the end of the day, you bring something of your own and focusing on that, focusing on your strengths and just tweaking your weaknesses is something I would encourage everybody to focus on. And I think this links to ultimately the fact that you should just do what you're comfortable with. What matters most is that when you go up to the podium, you are comfortable in your preparation and you're comfortable in what you have ready to argue before the court. And so, if you're the type of person that ultimately would feel most comforted by having a full written script, everybody says they want like point form, everybody says they want tables, but you think you need to have a script to feel safe, then just do that. Do that for yourself because that's what's going to help you and going to make you feel comfortable. And the final point would be, I think keep to what are your like little rituals or things that bring you comfort before a round. Everybody is different. I mean, for some of my friends, it's they have to take a walk before the round in fresh air, and I can understand that. For other people, I think it's things like okay. For me, particularly, I had a terrible '90s playlist that I played before every single round, in order to get myself out of the stress of that round, and that's something that I would do. So keeping a ritual that brings you comfort and that gives you confidence is ultimately the most important, and just having that knowledge that you are here for a reason. By the time you get to the international rounds, you are able to deliver before these judges, and all you need to do is just do your best. I think is ultimately just all you can do by the time you reach those sort of rounds, rather than hyperfixate on trying to be like somebody else.
Okay, one last question maybe that just came to my mind. Do you think in mooting, form is important? Which one of these two is much important, form or the substance?
Hmm. I think
As the best oralist approach of the Jessup competition, I'd like to know this, that do you think it's the way you make your presentation is much more important, the way you're giving roadmap, or for example the way you're dealing with some substantive issues? Which one of them is much important and make you win? For example, by this question, I mean, which one of them can make or help the team win a match in a moot competition, for example?
I think if you define form as roadmap structure, then I would say form is more important, because I think you can have by the time you get to the rounds again, everybody has a substance. Everybody knows the arguments. Everybody knows the authority.
Exactly.
The difference is in how
Yeah.
you present and package it. But I would say if the definition of form is more focused on, I think, accent or like presentation style, I would say that actually that may not be the big factor. I think in moods
Oh,
like the Jessup, um, I think in moods like the Jessup, even if you're really good stylistically as a speaker, if you cannot cite a single authority, you don't know the authorities, you don't know the arguments, your public international law foundations are weak, you will still lose to a team that is maybe not stylistically as strong, but that knows and understands the law and is able to engage on those points. So if the definition of form is very, very stylistic, I would say substance matters more. But if we're going to focus on form as in structure, packaging, presentation of arguments, clarity of those arguments, then I would in fact argue that form would support the substance. And having a good structure makes the substance of your arguments easier to understand and easier to receive.
Exactly. Definitely. Thank you very much, dear Erika, for this live and for joining us in this live. We learned a lot from you, and I hope that it was really useful for the students and for the audience from around the world who were watching this live. We hope that in the upcoming programs, maybe we can be at your service here in Iran, in Tehran, or other countries to learn from you more. Thank you very much, and it was really my honor listening to you and to learn from you. Thank you for joining us.
Thank you for inviting me. Thank you.
Have a very good night. I know that it's around 11 or 11:30 your time, yeah?
Yeah, but it's all right. I'm very happy to have this conversation with you. Thank you again.
Thank you very much. Have a very good time. Bye.